Jamie Benedictson. I'm a member of the Faculty of Law at the University of Ottawa and associated with the Centre for Environmental Law and Global Sustainability, along with the Centre for Natural Resources Law at the University of Calgary, organizers of this gathering. And it's my particular pleasure to welcome our speaker, Mr. Justice Gouge of the Ontario Court of Appeal. His subject, as you will know from the program, is the presentation of scientific evidence in the courtroom. His experience in that regard, and thus the background he arrives here to share with us, I think is perhaps unparalleled in the country. Let me simply mention some of the elements of that experience, a few of which I've had an opportunity to observe in the past. A few of you will recall the Berger inquiry and its vast impact on the development of environmental law in Canada and Native rights. Justice Gouge, as a young lawyer, litigator with the firm Cameron, Bruin and Scott, was associated throughout the time of that inquiry in a number of its pioneering innovations. He had recently graduated from the University of Toronto and was actively involved first with Cameron, Bruin and Scott and subsequently with Gowlings, being, I expect on a number of occasions, the actual presenter of scientific evidence and opinion evidence to decision-making bodies before his appointment to the court. He has been a member of the Ontario Court of Appeal since 1996. Justice Gouge has also, amongst a very wide range of efforts and initiatives to promote judicial education and legal understanding throughout the country, been actively involved with the National Judicial Institute in a program developing scientific training modules or opportunities for judges to learn about science and the science process as it appears in their courtrooms. He is also a man who gave his name, according to Wikipedia, to the Gouge Inquiry. He served as chair of the inquiry into pediatric forensic pathology in, I guess, 2007, 2008, and made extraordinary contributions in that setting. He arrives here with firsthand knowledge of the subject he's about to share with us. I also want to say, on a personal note, I had the opportunity and privilege as a young law student to sit in his classroom and study Native rights at U of T some years ago. It was a great honor then, as it is now a great honor to welcome him here.
Thanks, Jamie. I feel very old. What I'm going to try and do today is to talk a little from my perspective about the importance of scientific evidence, opinion evidence, and how we in the justice system may be able to, as we go forward, do a little better dealing with it than perhaps we have in the past. You will all know the power of expert scientific evidence in particular cases. Not every case where it's called before the tribunal, but there are cases where it is absolutely critical. And I'm going to come at this largely through the prism of the inquiry I ran, which turned very much on flawed scientific evidence that resulted in miscarriages of justice. The context back then was the kind of case where expert evidence really is critical. A case, this is not biological evidence. It is medical science, but it's nonetheless opinion evidence. But the kind of case that was the paradigm for expert evidence being determinative was an infant who dies in suspicious circumstances. There are only two pieces of evidence available on investigation. One is what criminal lawyers call exclusive opportunity. That is, who had the care of the infant when the infant died or had the fatal injury inflicted. And secondly, the pathology evidence about the cause of death. Those are the two pieces of evidence in cases that present enormously traumatic contexts for the justice system, for the families involved, for the community in which it took place, and for the rest of us. You can see from the paradigm that if the scientific evidence is flawed, the potential for injustice is enormous. So that presents the kind of the case where it's easiest to explain how it is that expert evidence really deserves scrutiny, and how we as a justice system need to do our very best to be able to cope with it in perhaps ways that are better than we've been able to cope with it in the past. We being all the actors involved, that is the lawyers, the experts, and the court. All three play a role, it seems to me, in coming to justice through the use of scientific evidence. We have to come to justice through the use of scientific evidence because whether it's that kind of case or the kind of case that is the implicit backdrop for the 2 days you're undergoing, expert evidence is critical. The justice system cannot operate without it. We need it, and we need to know how to evaluate it to best effect. The inquiry I did originated with a doctor whose name was Charles Smith. Back in the early 1990s, Charles Smith was trained in pathology. Pathology, like so many sciences, has subspecialties. Most pathologists are trained in clinical pathology. They support frontline doctors, specialists, and provide them with pathology opinions from reading slides and doing scientific tests and so on for living patients who are often desperately ill. There is another kind of pathology, forensic pathology. It adds to the pathology that a clinical pathologist learns two other things. First, learning about injuries, and secondly, learning about interacting with the justice system, because forensic pathology interacts with the justice system regularly. Clinical pathologists stay as far away from the courtroom as they possibly can. Dr. Smith began as a clinical pathologist. He was trained and worked at the Hospital for Sick Children in Toronto. He was, on occasion, early on, retained by the Chief Coroner's Office in Ontario for these very difficult, suspicious death cases involving infants. Why? Because nobody else would do them. None of his colleagues in the clinical pathology departments at Sick Kids had the slightest interest. They didn't like dealing with lawyers, they didn't like dealing with courts, and they didn't like dealing with cases that didn't involve patients that might be cured. Nonetheless, the hospital wanted to take advantage of his interest, and so did the Chief Coroner's Office. So the hospital created a position. They created a unit at Sick Kids called the Ontario Pediatric Forensic Pathology Unit, a unit of one person, Dr. Smith. That gave him a title, gave him an office, gave him a world-class hospital when he appeared in court, and that added to the credibility that his training appeared to give him. He was a commanding figure in a courtroom. I read many transcripts of Dr. Smith giving evidence and have run across many colleagues, judges, and lawyers who dealt with him. He was commanding. He could sound confident, sure of himself. He didn't brook opposition at all well. And his word was determining in many cases. He really rose to iconic stature in the field of forensic pathology, particularly involving infant deaths. in Canada through the 1990s. He was at the top of the pyramid. And because he was at the top of the pyramid, there were very few willing to take him on. So his evidence, his opinions, were critical in the determination of a large number of these terribly traumatic cases. Fortunately, a jurisdiction like Ontario doesn't have a whole lot of them. There'd be 15 a year. But when they occur, they're enormously challenging and enormously stressful for everyone. The genesis of the inquiry involved a few red flags that began to go up with Dr. Smith's work through the 1990s. The first involved a case out of Timmins in the early 1990s. A little 16-month-old girl who died in her home while in the care of a 12-year-old babysitter. A friend lived across the street. Families were close friends. The little girl adored the babysitter. The babysitter said that the little girl had fallen downstairs and hit her head. Dr. Smith simply thought that was impossible. His evidence, his opinion was that the child died by baby shaking, which in the early 1990s was a scientific theory that was gaining momentum. The family exhausted its resources defending the little 12-year-old girl. It brought in pathologists from other countries, particularly the United States, and in the end, a courageous provincial court judge found a reasonable doubt and acquitted the little girl and criticized Dr. Smith's modus operandi on the way by. The silver lining in the case is that the babysitter is now a Crown attorney in Windsor. The second case that was a sort of warning sign was a case out of Peterborough. Again, a little girl who was found to have died in the care of the babysitter, this time a teenage boy from upstairs. There was no question that this little girl had been brutally assaulted. She died of enormous, massive internal injuries. The only question was, when was the injury inflicted? Was it during the babysitter's watch, or was it on the mother's watch? And the timing was critical. So when the fatal injury was inflicted, a scientific question that involved forensic pathology was what the case turned on. Dr. Smith's evidence was that it had clearly been inflicted some 6 or 7 hours before the child died. That was when the mother had care of the infant. The mother's charged with second-degree murder. Her other siblings are seized by Children's Aid, and she spends time in jail awaiting the legal proceedings to unfold. Again, the defense was able to gather enough expert evidence to put on the other side of the scales, and finally, after 2.5 years, a courageous Crown attorney actually withdrew the charges. The police continued to investigate, and some 5 years later, the babysitter confessed. There's scientific evidence that it doesn't just have the potential for a wrongful conviction, but also, if done wrong, allows perpetrators to go free. The third case involved a case of some considerable notoriety, at least at the time of the inquiry I did. It involved a little 7-year-old who was found in the basement of her house, obviously having been brutalized. The issue was whether the mother had stabbed the little girl in the head, or whether some other cause of death, such as a pit bull, had been the cause of death. Again, the story unfolds as you would expect. Dr. Smith's evidence was this was clearly the mother. The criminal process begins to unfold, and ultimately it is determined that no, this was the pit bull that had killed the little girl. The last case which triggered the events that led to the inquiry I did was a case involving a 4-year-old who died in her bed in Sault Ste. Marie while the night before having been babysat by somebody who whose case has become well known. He's really quite an exemplary human being, a young man whose name is Bill Mullins Johnson. The evidence that Dr. Smith led at Bill Mullins Johnson's trial for first-degree murder was that the little girl had been strangled and sexually assaulted. That's first-degree murder. Bill was convicted of first-degree murder. The case went right through to the Supreme Court of Canada. The conviction was upheld. An organization called AIDWC, the Association in Defense of the Wrongfully Convicted, was indefatigable about the case. After a period of some 8 or 10 years, they managed to gather the pathology that Dr. Smith relied on for his opinion, the slides, the samples, and so on, and in order to get their own expert to look at it. When these pieces were assembled, with great difficulty by the coroner's office, great difficulty because it was difficult to find where they were, it was determined by a newly hired forensic pathologist, newly hired by the chief coroner's office, that a catastrophic scientific mistake had been made, and there was no evidence of strangulation, no evidence of sexual assault, that what had been observed were natural artifacts in a young body after death. So there was no evidence of any criminal activity. That was brought forward to our court as fresh evidence, and with the Crown's consent, Bill Mullins Johnson was acquitted. He served 12.5 years as a child killer in Kingston Penitentiary. That's what you call hard time. That led the chief coroner of the day, who was a new chief coroner, very courageously to call a blue chip inquiry into all the criminal cases that Dr. Smith dealt with over the course of the 1990s and early 2000s. That inquiry, which was made up of 5 blue chip forensic pathologists, all with international reputations, all of whom had been trained in forensic pathology, unlike Dr. Smith, they reviewed 45 cases and reported on April the 19th, 2007. They reported that of the 45 cases, in 20 of them, the results that Dr. Smith had testified to could not be sustained on the basis of the evidence that resulted in his opinion. In many of those cases, there had been convictions for serious offenses, so the miscarriages were obvious and numerous. The government immediately saw that confidence in the justice system, particularly the criminal justice system, had been significantly shaken, hence the inquiry I took on about 5 days later. And with all public inquiries, it was not designed to find fault or criminal responsibility. It was really designed to try to figure out what went wrong in the systems, to try to see what could be recommended to avoid replication. How can we do better so that we don't have these terrible miscarriages, these terrible events that are the antithesis of the justice that we all are endeavoring to provide. I won't go over everything, but I do want to use this as an opportunity to talk a little about my own view of how I think we can all do better with expert evidence. It isn't, I've been involved in a number of inquiries over the years, and most inquiries end with the report being handed in and the commissioner going back to work, doing what they do. And the reason for that is obvious. That is, much of what is said in the report of an inquiry is targeted at government. That is, recommendations for government to do this or that. And really, going beyond that as a sitting judge or even a retired judge in pressuring the government to take up their recommendations is not something that properly reflects the division between the judiciary and the executive branch. I wrote, perhaps a little offside, but I wrote a number of things that sort of were aimed at other actors other than the government. I mean, obviously I had a good deal to say that I thought the government should do, and much to my delight, they've done almost all of it. But you know, it wasn't just government that was at fault here. All the actors in the system had to bear a responsibility, and all could do things better in the future. And I tried to say some things about how that could happen, you know, how it can be that lawyers who participate in cases involving scientific evidence, how experts involved in cases giving scientific evidence, and how the tribunal evaluating scientific evidence can all approach their task a little better than they have in the past, with hopefully the chance as a result that justice will be better served. What kind of things were exemplified by the science we saw in the cases we looked at that Dr. Smith had engaged in? Well, obviously, you know, the flaws won't surprise you. There were flaws in his written reports. There were flaws in his testimony. He did not understand his duty to the court. He began his career in forensic pathology thinking that his task really was to assist the Crown getting a conviction, as opposed to assisting the court to find the truth. He testified often outside his area of expertise. The reason I'm giving you this, I'm going to come back to it, because I think it sort of exemplifies the kind of thing that lawyers, experts, and judges need to be alert to in dealing with expert evidence. Testifying outside his area of expertise, a common question Dr. Smith was asked back in the 90s when this live debate over baby shaking was front and center was, okay, Dr. Smith, give me the psychological profile of a baby shaker. And he would, hardly surprisingly, describe baby shakers as new boyfriends, drunk, out of work, 5 o'clock in the afternoon, crying infant, okay? Hardly surprising. Giving that kind of opinion, here's the psychological profile, is something Dr. Smith was no more qualified to do than I am. I mean, he had absolutely no scientific basis to give that kind of opinion evidence. Lacking in particular experience, let me give you an example, hearkening back to the dog bite case. In being introduced as an expert in the dog bite case, Dr. Smith was asked, had he done cases involving dog bites? Answer, yes, he'd done a number. Turns out he'd been a bit player in 2. So an exaggerated expertise was something that was exemplified by some of these cases. Basing his opinion on non-scientific information, something we all do, but as it comes to the court, one has to guard against it. One of the reasons in the case from Timmins that he formed the opinion that this had to be baby shaking and couldn't be the little infant falling down a short flight of stairs in the house is that he'd had kids, they'd fallen downstairs and they survived. Not much science. Non-scientific information as the basis for opinion, exemplified. Simply misunderstanding the science. Bill Mullins-Johnson case is a prototypical example. Okay, those are the kinds of flaws. So I'm not going to go through in detail the kind of recommendations that I made for each of the actors in the system in broad terms, obviously. And I do want to say something about this in connection with environmental evidence. The field of expertise from which the expert comes can make a difference. It's interesting with hindsight that this set of examples of how scientific evidence resulted in injustice comes from an area that one would think of intuitively as hard science. Science that is regulated for quality control. Medicine is highly regulated in terms of quality control. It is not what I would call a soft science. And yet, even there, the opportunity for misinformation and opinions that lack scientific validity is obvious. So the way the field of expertise from which the expert comes organizes itself, I actually think makes a difference. Let me give you an example that's not related to biology but is related to expert opinion. I've done a number of talks since I finished this task to family lawyers and family law judges. They get expert evidence all the time from child psychologists saying things like, who's the better parent? Okay? The scientific basis for that, they acknowledge, is pretty thin. And the best of the field in that area are working hard to kind of create some kind of internal discipline in the expertise so that quality control can be internally imposed or internally encouraged. That's something I think most fields of expertise that interact regularly with the court system can profit from. Best practices, obviously, career professionalizing, oversight, I'm going to come back to that too. Oversight, particularly in the medical field, that's not necessarily true in the academy, and a lot of opinion evidence comes from the academy. But take medicine, for example. If you went to a tertiary care hospital and sought an opinion, it would amaze you if the opinion came from one doctor never having talked to his or her colleagues. I mean, that's just not the way highly skilled scientific evidence is done these days. There is a peer review process, opinion by opinion, that takes place. Why? Because that produces the best science. Translate that into expert evidence, and you can see that an opinion that comes not having been peer reviewed perhaps lacks a validator that warrants a little extra scrutiny. It doesn't always. But it may be something. So oversight was a critical institutional issue that I had to say something about, given that forensic pathology is done in hospitals, okay? So that's the kind of thing. I'm going to quickly go over communications between experts and the justice system, because I actually think that ended up being one of the things I became interested in. Communications like, does the expert understand the expert's role? Is the expert basing the opinion on epidemiology or ex cathedra statements, to take two extremes, or something in between? What's the choice of language? Choice of language is really slippery. And those of you who see expert reports in writing tendered by experts before they give evidence as they're exchanged with counsel, you know, it doesn't take much to see language that may mean one thing to the scientist and mean something quite different to the justice system, to the lay justice system. The phrase that epitomizes that best is consistent with. The evidence is consistent with the following opinion, okay? What's consistent with mean? Does it mean equally consistent with something else? Does it mean only consistent with? And so on. You know, language is slippery. The example I use, common thing, it's probably happened to a number of you guys. You go into the doctor, you got a sore throat, you open your throat, the doctor looks in it, it's red. Doctor says, you got strep throat. You hear that as the doctor saying, for sure, I got strep throat. The doctor's saying it as, you probably got a 20% chance of strep throat, but it's the most likely thing, so I'm going to treat you for strep throat. Vast difference in level of certainty based entirely on language, okay? And that's something I think those of us in the justice system, lawyers and judges, need to pay way more attention to in order to be sure that we understand the thought process that the scientist is trying to communicate to us. I mean, they use their own language. I mean, and you know, there's no reason why they should put themselves in our shoes. But we've got to be smart enough and acute enough and aware enough to be able to ferret out what they are truly trying to say to us, rather than simply take what we implicitly assume their language to indicate to us. Okay, the certainty with which the opinion's held. I just gave you the example. Let me talk a little, though, about, because I want to leave a little time for questions, about doing better in the context of the court, and use that as a way of perhaps providing some things that seem to be relevant to me at the time. Obviously, it's in everybody's interest, lawyer, judge, expert, to avoid outcomes that are the product of tainted science. And so everybody's got to play a role in that. In a technical sense, All you folk I know and know the Mohan criteria: relevance, necessity, no exclusionary rule, and a properly qualified expert. 4 things. Built into necessity and relevance for me is a fundamental criterion, and that is this notion of reliability. It's hard to say that expert evidence that is unreliable could ever be necessary. It's equally hard to say that expert evidence that is unreliable could ever be relevant. My colleague Louise Chiron has written about both those factors having as an underpinning this notion of relevance. In a criminal trial, obviously, it's critical, and the judge has a gatekeeper role to ensure that before evidence gets to the jury, it gets through this threshold screen of relevance. In other words, you're not of reliability. You're not going to ask a jury to act on it unless it has a fundamental possibility of reliability. But even in a judge-alone trial, the same thing applies. That is, a judge really has to determine at the end of the day how reliable expert opinion is in order to base an outcome on it. And this is a task that I think lawyers need to perform for themselves in both calling, that is, preparing and then calling the expert opinion, and in cross-examining it. Ultimately, I think, you know, if we could figure out a way to do better at demonstrating the reliability or the unreliability of expert opinion evidence, we would have gone a long way to improving our ability as a justice system to deal with it. And that's not just in the sort of area of novel science, junk science. That's where it sort of comes up most commonly in the case law. That is where it's junk science. People like Sapinka have said, you really got to focus on whether this is reliable or not. Take Dr. Smith, you know. That's not novel science. That's not junk science. Forensic pathology has been around for a long time. And when he gives evidence that a little girl has died after being sexually assaulted and strangled, how reliable is that? Well, that's the task of the court. It's the task, I think, as well of the lawyers involved in the case, but it isn't just junk science, novel science, to which this notion of reliability, I think, needs to be applied. Okay, I can do this from the perspective of the court, but it applies equally to the perspective of the lawyer preparing either to call or to cross-examine expert opinion, scientific opinion. One of the things that seemed to me to jump out at all of us, frankly, as I engaged in this, was the notion of the roaming expert. And I know I did this for 25 years as a litigator. You'd get the thickest CV you could. You'd introduce the witness, the scientist. You'd table the resume, and you'd sit down and hope the expert told the story. And it didn't much matter where the story went, whether it stayed confined within the expertise or went into areas that were a little offside but helped the case. It was obvious in a number of the cases that led to the inquiry I did that that was a significant flaw in the way the system dealt with scientific opinion. So figuring out at the beginning what the ultimate boundaries of the expertise are that are being offered by the expert who's delivering this opinion, I think is critical. I actually have tried to say to judges, and I've done a fair amount of speaking after my report, I think judges have a particular responsibility to set up this definitional task at the beginning of an expert. Why? Because it is a little hard to close the stable door after the horse is out. Not so hard if it's a judge alone, real hard if it's a jury. So you need to figure out what the outer limits of the expertise is that are being offered. And that comes in the qualification process. I think counsel have a real role to play in that too. So often, and I did it myself, you know, there'd be no need to qualify the expert, and there'd be no objection from the other side, and you just assume the expert is there, and nobody ever engages in the intellectual task of trying to figure out what the expertise, what its limits are. so that you know when the opinion that's given is within it, and you know if it strays beyond it. So that's kind of the threshold. What then do you do about assessing the reliability of the evidence that's offered? Well, obviously, the first thing is it within the area of expertise that I've just talked about? Is the opinion evidence-based or personal? Back in the 90s, certainly for forensic pathology, and I know from my own experience in other areas of expert opinion, ex cathedra statements were the order of the day. Old white scientists saying, I know it because I'm telling you. That's not good enough. We now require evidence-based opinion. It has to have that evidence. It has to, if possible, be based on epidemiology. The ideal gold standard is what the Americans in Dobert require, and that is testability and error rates. That is, one has to be able to replicate what the opinion says was the cause of the opinion, and determine how often that happens exactly as the expert says it should happen and what the error rates are. From my own perspective, that's a gold standard which can be observed in some kinds of expert cases in the justice system, but often not. I mean, you can't get testing and error rates for suspicious infant deaths. You just can't. And yet we need the expert evidence. So there will be many kinds of expert opinions for whom testing and error rates is not available as a device for checking for reliability. But if it's there, it's obviously an excellent criterion for evaluating reliability. Is the technique that's been used to generate the opinion accepted in the field, and is it peer-reviewed? Is it an opinion that is based on facts that are gathered accurately, and are they subject to quality control? And as you know, most opinions will be given either on the basis of facts that are in evidence already or hypotheticals that lawyers put to experts. But either way, the fact base for the opinion has to be measured against the accuracy as demonstrated by the rest of the evidence. Is the opinion peer-reviewed? I've talked about that as a way of providing some guarantee for institutional backup for the opinion. Does the opinion account for inconsistent facts? Does it account for alternative explanations? Is the language used clear, understandable, and unambiguous? Is the level of certainty articulated? That's the doctor example of the sore throat. Is the expert dogmatic or willing to make concessions? And has the expert made previous serious mistakes? I haven't dealt at all here with bias, which is a whole other area of expert opinion. And when I talk to my American colleagues, their gigantic diversion is with experts who are biased. They think no expert is not biased. I actually am not quite as alarmist as that. I actually don't think that's the case. I'm much more focused on how can we all collectively evaluate the opinion that is given, the scientific opinion that is given, and determine to some extent its reliability. It's not easy. If you guys are like me, you went to law school because you couldn't do science. So how the heck are you supposed to determine whether scientific evidence is reliable or not? Well, I don't think it's impossible. I really don't. Okay? I decided not to write a paper for this because I did a chapter on it in the report I wrote, which I'm sure is still online. This is actually a book tour, not a lecture. But it does provide a series of shopping lists of these simple criteria. It's actually interesting when you go to the case law. There's a ton of case law about the criteria for admissibility. That's Mohan. A successor to Mohan that is, if you get a case like this, well worth looking at is a case that my colleague and close friend David Doherty wrote called Regina and Abbey, where he kind of unpacks the workability of the Mohan criteria. That is how it is that a trial judge ought best to approach applying the criteria. That was a case whether a tattoo on a cheek represented in a gang war the evidence that you'd killed somebody. So it was sociology. But even David, for all his brilliance, doesn't deal much with how you go about, once you've got the criteria there, once you've determined that the opinion passes the criteria and therefore is admissible, how do you engage in the mental analysis of determining its reliability? And that's a nuts and bolts question for me. And it does kind of reduce itself to what's a series of considerations, none of which are silver bullets in this, but some of which may be applicable in a particular case to help you as lawyer or you as judge determine whether the opinion is reliable enough to be able to act on. In the end, one of the things that I took comfort from myself in this exercise is that while we're not great at science, although we should be getting better, and the NJI science manual that Jamie referred to and that several of us here I know are involved with, will provide assistance for judges, and there are science and law courses being offered in the Legal Academy increasingly. So there are steps taken to make lawyers more conversant with science. But in the end, a ton of us who haven't had that benefit are going to have to engage in this notion of testing scientific opinion for reliability. In the end, one falls back on one of the things we are good at as lawyers, and that's thinking logically. I mean, if there's any skill set we have that allows us to say we can bring a specialty to this task of evaluating scientific evidence for reliability, it's thinking logically. And one way to approach scientific evidence, to think about it as reliable or not, is to ask, well, what are the facts? Are they there transparently? What's the reasoning process that builds on those facts? Is it transparent? Can I follow it? Is it logical? And does the conclusion, i.e. the opinion, flow from that process, the facts, the reasoning process, and the consequence? You'll see by sketching it out that that's the Shepard test for writing judgments. That's what the Supreme Court tells me I'm supposed to do. It's not a bad metaphor for saying, here's one way that we can come at this as non-scientists tasked with the job of saying how reliable is scientific evidence, using a skill set that we're familiar with and that we know and that we're good at. So it is not by any means a hopeless task. It's a task that I think we can all continue to get better at. And one of the things that has been most heartening for me in the 2 or 3 years since I tendered my report is that as I have the chance to talk to lawyers and judges and experts about this general challenge, it is astonishingly heartening to see how all the actors in the system want to strive to do better at this. They want to be able to do this task better and therefore deliver the product of justice in the best possible way. We're pretty lucky to have a system with participants that approach this task that way. So I hope you do too. Thanks for listening to me.
Thank you very much. It is my understanding that if I were Jerry Springer, I would wander around encouraging you to leap up with pointed questions, but we are operating on a system that involves somewhat more decorum and less effort on my part. So I'm just going to sit here downstream from questions that may come in. While that is happening, I have, and some are on the way, I've got one to launch with, if I may. It seems implicit in the presentation that scientific opinion evidence is scientific opinion evidence. That is, the subject matter, for example, cause of death or an engineering dispute, doesn't make much difference. Is that a fair assessment of your view, or do you have some sympathy for specialized environmental courts or tribunals, such as we've begun to see in a few jurisdictions like New South Wales in Australia?
I have a huge sympathy for specialization, Jamie. I really do. I think in a complex world, specialization is the way of the future. I have spoken as if a court of general jurisdiction could be handed a case today involving forensic pathology and tomorrow on environmental pollution in a northern mine. I do think there's a commonality in the approach to expert evidence. Familiarity with the science, though, is going to be an enormous advantage. It just is. And it does seem to me that as a consequence, a specialized tribunal is going to be able to do justice with less risk of error through scientific opinion that is unreliable than a court of general jurisdiction. I think that's right. You know, I do, though, say that all of us, I mean, we're all going to be faced with it on an increasing basis. You know, as the world gets more complicated, that, you know, you as lawyers and judges, and certainly in my experience in the last 17 years, you just get faced with scientific evidence in cases that you would never have been faced with it in 30 years ago. That's just the way of the world. So we all have to get better at it. I think specialized tribunals get better at it better, if I can put it that way.
Could you comment or offer any thoughts on the special challenges that are raised by the presentation of highly technical evidence in jury trials?
In what?
In jury trials.
Right.
What's the judge's role in providing appropriate cautions and guiding the jury about how to weigh that evidence?
That's a huge challenge. It really is, and I want to broaden the answer to take into account both judges and lawyers. I think lawyers have a huge responsibility in cases that are highly technical to work with the experts before they stand in front of the jury and try to explain it. That is, it's going to be nothing but confusing if the lawyer hasn't engaged with the expert. And there are all kinds of risks there. I mean, you know, we all know the risk of the lawyer trying to guide the expert to the right conclusion. What I'm talking about is the professional responsibility the lawyer has to get the scientist to explain the scientist's view in a way that a lay group of 12 people can understand. And I think that's very difficult. And it takes more work than I think most lawyers have the time to give. I mean, if there was any, in the inquiry I did, we heard a lot of experts, not talking about the particular cases, but talking about the generic challenges that we were supposed to try to make recommendations about. If there was any single difficulty that experts as experts felt in the justice system, it was that the lawyers did not spend enough time with them. Did not spend enough time with them. And that has to do, I think, both with the ability of the trier of fact, jury or judge, to understand it. It also has to do with the degree to which the expert understands his or her own task. So I think You know, I know the pressure of docketed hours and stuff. I lived that. But I think if lawyers have a significant role to play in trying to ensure that what is presented by the expert is comprehensible by the trier of fact. I must say, I think juries are every bit as smart on this as judges are, so it doesn't mean you have to go the extra mile if it's a jury case. You probably do if it's a judge too. So, you know, but the judge does have a role in cautioning the jury to, you know, understand what they're hearing. But I really do think the lawyers bear the primary responsibility there.
Here are a couple of questions that I think probably flow, in a sense, from comments you've just made. I'll put them out together in the interest of time. Can you offer some concrete advice to counsel, to lawyers, about how they should go about assessing the credibility of an expert, perhaps when they're making a selection? And is there any guidance in our civil rules of procedure that you may be aware of that address experts' obligations to impartiality or duty to the court and matters of that kind?
In civil cases, there is now a certification an expert has to make that they understand their duty is to the court. Okay, so that's some calculus that says there at least is a certification that the expert, having signed it, seems to have undertaken. What was the rest of the question?
Some combination of how you would assess credibility and
Okay.
the rules of court
Okay.
that would promote impartiality and.
Okay. That sort of comes to my shopping list approach to reliability. That is, it does seem to me that, I mean, credibility is an elastic notion, and let's set aside the bias component of credibility for the moment. That's a whole other question. But assuming the scientist is an objective pursuer of the truth, and frankly, I'm prepared to make that assumption in almost every case. So that bias isn't really a question. Bias meaning I'm going to tailor my opinion to the result the person paying me wants, okay? If the person giving evidence as an expert is an objective scientist, there still is a fundamental task of how reliable is the opinion, because science, you know, today's truth is disproven tomorrow, and that's tomorrow's truth. The kinds of indicators, the kinds of tools that I've tried to talk about today, I hope will be of some help. As the lawyer sits down to assess, let us say, the expert that the lawyer proposes to call as the expert for the lawyer's case. It's not easy. You know, and due diligence surrounding inquiries of peers and so on may be helpful. But ultimately, the lawyer has to face up to the task of, here's the opinion that's being offered, here's the basis on which it's being offered. I have to make a judgment. It may be the best you can do, and then it'll be over to the court to determine whether it's reliable enough to be acted on. It is a tough task. On the other hand, if it's preparing to cross-examine, in a perfect world, both sides will have experts. It's not a perfect world. Resources are not equal. I know that. So that this paradigm doesn't always work. But clearly, reviewing the opinion of the expert that the other side is calling with one's own expert will be an avenue to develop things in it that may be less than reliable, okay, or may put it further down the scale of reliability than would otherwise be the case. The tough cases, Jamie, are the cases where there's a resource imbalance. And that often happens, particularly in criminal law. And there's no easy answer to that.
Here is a question with a kind of an institutional dimension to it, do you see any inherent difficulty in determining the reliability of an expert witness who's employed by an investigative agency of some kind, working with a group of researchers, perhaps? The example given is the habitat biologist who's come before the tribunal or court to draw conclusions based on evidence gathered by his or her colleagues, a kind of a team process.
Okay, there are two aspects to that, it seems to me. One is, does the expert always work for the hydrocarbon company, for example? Okay, and hearkening to what I said, back to what I said about experts in American court work, they are plagued by that. My own view is perhaps naively to take as a given the scientist's desire in the witness box and in preparing the written opinion to do the scientist's best in delivering what the scientists think is the best opinion, regardless of who's paying them, who they've worked for in the past. Now, that isn't to say at the extremes there aren't accusations of bias that can be made and established. But let's get over that and assume that we have a case where a scientist is seen as somebody who's really attempting to get at the scientific truth. What difference does it make that the facts that the scientist uses are facts that have been gathered by a protagonist? It seems to me that that does come back to the notion of, are the facts that the opinion is based on accurate? Have they been demonstrated as the foundational facts that the tribunal is going to have to reach its conclusion on? Because if they're not, then the opinion is to that extent skewed. Okay? Once again, it doesn't seem to me that who gathered the facts is as important as, are they accurate in the sense that, is that the range of facts that are before the tribunal and are going to be acted on? I mean, obviously you take account of who gathered them, but it's much more for me a matter of whether the facts have been selectively put forward. Okay? Thank you.
I think we're pretty close to the end to offer a reminder to convene at 9 a.m. for two panel sessions, one on science and advocacy and one on defenses in the context of environmental prosecution. In closing, I'm going to go on a limb. I'm told it's risky to use such phrases as consistent with. But I am going to say that this presentation was consistent with my experience in Justice Gouge's classroom. Some years ago, it was wise and thoughtful and insightful and stimulating, and thank you very much.
Thanks.